Mr. Speaker, sir, I am thankful to the Honorable Member of Legislative Assembly, Shri Edelbert Nongrum, for tabling the 0-hour notice under Rule 49A relating to a news item published in the newspaper Highland Post dated 5th February 2021 under the caption, Government urged to make marriage certificate mandatory. So it provides this House an opportunity to discuss the very important subject of registration of marriages in the state of Meghalaya, threadbare and address the issues involved in the interest of the citizens of our state. The concern expressed by the Honorable MLA, Shri Edelbert Nongrum, is praiseworthy. I am also thankful to the Honorable Speaker, sir, for admitting the notice on this matter of public importance. Mr. Deputy Speaker, sir, since independence, numerous initiatives have been taken to address the issue of gender equality, and reform measures taken in this direction have yielded positive results. However, child marriages, bigamy, desertion of women by their husbands, and gender violence, etc., continue to persist in our society, despite various legislations prohibiting and penalizing such practices. Several disputes are pending before the courts regarding matrimonial status of the parties, and women are often denied the status of wife due to absence of record proving a valid marriage. The courts have time and again emphasized on making registration of marriage compulsory to prevent denial of status and legal rights to women and to children born out of wedlock. Instances of marriage frauds have also come to light in recent times in developing countries. In the absence of compulsory registration of marriages, women are duped into marrying without performance of the conditions of a valid marriage. This deprives women of societal recognition and legal security. Such fraudulent marriages are especially on the rise among non-resident Indians. It has been found by scholarly studies and empirical researches that compulsory registration can serve as a means to ensure that conditions of a valid marriage, such as maintenance, legitimacy of children, etc., have been fulfilled. A marriage solemnized under a religious marriage ceremony is considered as a legal marriage in the eye of the layman. However, a legal marriage registration certificate will prove one's marriage valid under the court of law. A marriage certificate is an official statement establishing the marital status of a couple. It is an important document which one can rely upon to prove that they are legally married to someone, and for various other purposes like obtaining a passport, opening a bank account, changing one's maiden name, and applying for an income certificate, among other things. A marriage certificate is essentially the legal proof of registration of a marriage. Without compulsory registration, women are deceived into marrying without fulfilling the conditions of a legal marriage. So, registering a marriage is most important from the women's empowerment point of view. A valid marriage registration certificate will not only help a woman to get maintenance from her husband, but also to get her share in her husband's property and to get other matrimonial benefits. Registration of marriage would address the issues of marriage frauds, bigamy, and other help in better implementation of already existing laws that aim at preventing social evil such as child marriage, etc. It would also aid in eliminating practices of early and forced marriages and provide an enabling framework for achieving gender equality and empowering women in this direction, benefiting the society as a whole. In Meghalaya, it is seen that practice of cohabitation without entering into formal marriage and registration is prevalent, and this leads to high rate of desertion of women by their husbands, and the women are left to fend for themselves and their children in the absence of any document to prove the marriage. To address this problem, the Meghalaya Compulsory Registration of Marriage Act 2012 was enacted to provide for compulsory registration of marriage in the state. The 2012 Act has made registration of all marriages contracted in Meghalaya mandatory, and in addition, it also provides that for all official purposes, production of the registration certificate by the couple is mandatory, which is clear from its object and reasons. The object is further clear from provisions of Section 2B and 2I, which defines marriage and to contract a marriage, making the Act applicable between persons belonging to any caste, tribe, or religion, and the marriages contracted as per any customs, practices, or traditions, and which includes in its purview even the remarriages. Further, it is made applicable on a marriage in any form or manner, in accordance with any religious custom, practices, or traditions, and includes all marriages under personal laws. By an amendment of the Principal Act in 2017, Sections 3A and 3B were inserted, which provided that all marriages in Meghalaya shall be deemed to be taken under the 2012 Act, and that the provisions of the Act were further made applicable to the parties to the marriage or in case of living together or cohabitation not covered by their respective personal laws. Thus, the applicability of the Act of 2012 covers all marriages and similar cohabitation in Meghalaya. Section 3 of the 2012 Act provided that after the date on which the provisions of this Act have been brought into force under subsection 3 of section 1, every marriage contracted in the state shall be compulsorily registered in the manner provided in section 5, and such marriage certificate shall be required for all official purposes. However, the term official purpose was never defined in the Act. The latest amendment of 2019, Act number 8 of 2019, has merely defined official purposes as contract of marriage entered between the parties for addressing issues pertaining to pension, succession, and maintenance of spouse, which is nothing but a clarificatory amendment without any prejudice to the object of the Act of 2012. The mandatory provisions of compulsory registration under Section 3 of the Act has not been done away with. It has only been clarified that for what official purposes the submission of registration certificate of marriages is required to be furnished. The term official purposes as defined addressing the issues pertaining to pensions, succession, and maintenance of spouse is not restricted in its application of government, central and state only. It has universal application, extending to all persons, entities, be it government, semi-government, private, etc., in the absence of any restrictive qualification to government only. Also, it does not mandate the requirement of having a compulsory marriage registration certificate for purposes such as to apply for passport, ration card, home loan, and registration of joint property, etc., other than for the purpose of 1. Pension, 2. Succession, and 3. Maintenance of spouse. Accordingly, it would be optional for the people to produce marriage registration certificate under this Act in order to avail these services and facilities as and when required. The definition of official purposes included 3 critical rights arising out of any matrimonial alliance, vis-a-vis pension, succession, and maintenance of spouse. And the Act does not have specific injunction for registration of marriages for purposes other than the defined under the official purposes. The letter written by the concerned citizen is being examined by the department, and after obtaining the views of the law department, while also looking into similar acts by other states. Further course of action will be taken accordingly in the best interest of the people of the state. Thank you, sir.